Namaste ji, namaste. So today we'll talk about bhai ki capacity to drink. No, two of making a contract. All right. So four sections that you're going to mention in your answer straight up. Section 10, section 11. Then you're going to go to the specific relief act and go to 39 and 41. Here they are. In the new act, they are 31, 33. But when we get to these case laws, we'll discuss what is 31, 33. Now, what exactly is happening here? So, section 10 is saying that you need to be competent to contract. Now, what exactly is that competency? और ये आपके LLB 2019 के entrance के exam में भी था question that whether it's a capacity to contract, whether it's competency to contract. Now you know where they picked up that question from. Section 11 के अंदर तीन चीजें दे रखी हैं. That's minor नहीं होना चाहिए, unsound minor नहीं होना चाहिए, and disqualified by law नहीं होना चाहिए. So we're not concerned with the other two, only concerned with this bicep. That what if you're an infant, what if you are a minor, then what exactly? You're not competent to make a contract. But neither section says, neither of it, that what happens when a minor enters into a void or avoidable contract. Now what exactly will happen then we need to consider our case laws. So first one is Mohri Bibi, the second one is Khan Gol, the third one is Ajudhya Prasad. So whenever I'm going to teach these case laws, you're going to elongate the facts from your case maths. I'm just only going to teach you the core and material facts only. The longer one जिनमें आंसर आपने लंबा अपना खींचना है वो आप अपने आप से निकाल के लिखेंगे. तो अब इफेक्ट क्या है इसका कि जी ये आपके लिए ये void या voidable क्यों नहीं है? क्योंकि कॉन्ट्रैक्ट ही नहीं है ना. कॉन्ट्रैक्ट हो ही नहीं सकता. जो कॉन्ट्रैक्ट नहीं हो सकता then what is the remedy under the Indian Contract Act? Well, it does not exist because let us say, for example, let us say that this is the contract. This is my 2014 wala case mat which I still refer to. That's why secure your case mat, don't throw them away. It's very useful later on in life, maybe if you get into teaching. Let us say that this is the Contract Act. So if I as a judge have to give the relief, I have to give it under this book of law only. Trouble is that when it's not a contract to begin with, how do I exactly refer to this book? This is the case that is happening here. So that is the core funda कि void voidable तो तब होगा ना जब contract होगा. जब contract ही नहीं है तो तब क्या करें? तो इसी के लिए हमने case laws देखने. तो अब effect यही है कि भाई जो भी क्या minor ने वो आप ICA में तो नहीं पकड़ सकते क्योंकि as I told you it's not a contract. So 3 points we can summarize and these 3 points mentioned in your answers if it's a 20 mark of course. No estoppel against minor. So for example what can you say now कि minor तुमने धोखा दिया, तुमने झूठ बोला, now we will e-stop you. So what is an estoppel? Promissory estoppel की तरह e-stop you from taking the claim of or rather defense of infancy in court कि we will not allow you to tell that you are an infant. Now we will basically allow you or rather ask you to be treated as an adult in the court of law because that is what the basis of your entering into contract was. So defense of infancy आपके रोक नहीं पाएंगे हम. So there is no estoppel against a minor. कि नहीं अब तुम माइनर नहीं बोल सकते अपने आप को, ऐसा कुछ नहीं है, वो अभी भी कर सकता है. दूसरा, देयर इज नो लायबिलिटी इन कॉन्ट्रैक्ट एज आई सेड कि कॉन्ट्रैक्ट के अंदर आप इसको नहीं पकड़ सकते. पकड़ेंगे कहाँ इन भाई साहब को? Doctrine of restitution, and this is the core crux. Understand this and I think everything will be clear. तो इन तीन केस लॉज के अलावा आपने एक केस लॉ मेंशन करना, that is Leslie versus Shale, और इसका आपने सिर्फ नाम देना है. You can skip the facts, you can skip what happened, but all you can say is that this doctrine of restitution means to restore something. Is this Ganga is basically flowing from this Gomukh, यहीं से निकल के आ रही हैं और यहीं this is the source of the doctrine of restitution. Now, understand this, that if he obtains goods or property, that is the minor. So we are talking about equity here. So this is a doctrine of equity. What is equity? कि वही अपना good conscience, justice and good faith and all that, कि हम equity के अंदर आ रहे हैं तो अगर equity के अंदर दोनों parties के हाथ साफ होने चाहिए. ये नहीं हो सकता कि आप you go to a code of equity in which both parties are basically आपको law के हिसाब से तराजू से तोला जा रहा है and then justice being meted out. that एक आदमी अपने ही फ्रॉड का एडवांटेज लेने आया हुआ है, वो वैसा नहीं अलाउ करेंगे ना कोर्ट ऑफ लॉ. सो योर हैंड्स हैव टू बी क्लीन ऑफ द बोथ द पार्टी. सो इफ द माइनर obtains goods or property, then as per equity or the principle of equity, which is the doctrine of restitution. So now what just happened is that I explained everything and found out that the phone had stopped recording. So now I'm going to do it again. Anyway, so if the minor obtains goods or property, तो आप उसमें से the court can order him to restore it, provided that you can trace it back in the same condition or the same thing. So for example, let us say that a minor gets into a contract with me and takes an iPhone from me, and tomorrow he says कि boss मैं तो minor था, आपको पैसे वैसे तो मैं दूंगा नहीं. If I can tell the court, as per this doctrine, that वो रहा iPhone, if we can trace it back, the court can say, भाई साहब, restore the iPhone. All right. So this is very critical thing, and this is everything depends on all the three case laws that are coming will depend on all of this. So you want to mention this, Leslie versus Shale, and अब यहाँ पे क्या करेंगे? If he has sold or converted, but if he has sold, let us say that minor sells it or converts it and then later on buys a PS4 or something, I cannot now basically go to the court, and the court cannot ask him to restore that iPhone because that iPhone is now gone. Asking him to restore that iPhone will basically be akin to enforcing a contract. So a contract था ही नहीं, तो voidable वाली वही बात हो गई. तो अब जब contract था ही नहीं, तो how do we ask him to enforce or restore what he has gotten? So this doctrine is being used now. Let us come to the case laws. So where is this doctrine in the Indian Contract Act? मतलब कहाँ पे दी हुई है? This is actually not in the Indian Contract Act. This is in the Specific Relief Act. तो judiciary के लिए यही doctrine इसी topic में से आती है. It's given in section 41 of the old act 1877, and you'll notice these arrows because I've actually gone through all of this and now I have to do this again. So anyway, तो justice और compensation यहाँ से, so Mohri Bibi versus Dharmadas goes के अंदर short facts. You're going to elongate these facts. You're going to थोड़ा सा अपना आंसर लंबा बनाने के लिए केस मैट में से आप अपने facts निकाल लीजिएगा. So चौधरी साहब gave our infant साहब an amount of 10.5, 20,000 की बात हुई थी, in exchange for a mortgage of his properties. So the infant commenced action कि boss, look, I'm an infant, मेरे को छोड़ दो, ये तो हो ही नहीं सकता. Now, so the attorney जो केदारनाथ जी थे इसके अंदर, he was, before advancing this 10.5 thousand rupees, he was intimated कि boss, this guy just maybe a minor, be very very careful. But he, I think, got overconfident as a lawyer कि अरे देख लेंगे, कोई legality नहीं, कुछ नहीं होता. He got into a contract. He made him sign a very long declaration of a false thing in which he said that infant जो कि सितंबर में I think जिसका बर्थडे आना था या बाद में आना था, so जून में ही जी आपका बर्थडे आ गया, now you are a major. And the trial court and the appellate court found that this letter was actually sent to him and there was conclusive proof. But the lawyer obviously denied having received such intimation. So the defense that Chaudhary ji took in this case was section 64 of the Indian Contract Act. But the judges said, look boss, that is only for voidable contracts. आपका contract तो कॉन्ट्रैक्ट है ही नहीं, आपके केस में तो कोई कॉन्ट्रैक्ट है ही नहीं. वॉइडेबल तो बाद में आएगा जब कॉन्ट्रैक्ट होगा. तो वॉइडेबल सर्टेनली क्या प्रिज्यूम करता है? और कॉम्पिटेंसी प्रिज्यूम करता है. इट प्रिज्यूम्स दैट द पार्टीज आर कॉम्पिटेंट, सो दैट देन ओनली कैन द कॉन्ट्रैक्ट गेट इनटू द वॉइडेबल टेरिटरी. नो, सो सेक्शन 64 ICA वाज थ्रोन आउट. नाउ सेक्शन 41 ऑफ द स्पेसिफिक रिलीफ एक्ट, दे सेड मूड नहीं है हमारा. कर तो रिलीफ तो दे सकते थे डॉक्ट्रिन ऑफ रेस्टिट्यूशन से, बट दे सेड मूड नहीं है हमारा. Of course not, that was not the reason, but slightly it was also. The judges said, look, in a code of equity, you have to come with clean hands. You knew that this guy was a minor. There is conclusive proof of that. You made him sign a very long declaration of a wrong birth date. You basically told him, you were very overconfident that हाँ मैं देख लूंगा मैं सब कुछ. आप पहले ही झूठ पे चल रहे थे और आपको ये सब मालूम भी था. सो यू वर रॉन्ग टू बिगिन विद. सो अंडर equity, under this doctrine of restitution, we will not be able to grant you relief. So whenever you go to a court of equity, you have to go there with clean hands. मतलब दोनों parties सच के साथ ही आ रही हो. You cannot go there to take advantage of your own wrong. So herein you were wrong. अगर ये यहाँ पे नहीं होते तो sure enough इनको रिलीफ मिलने के बहुत हाई चांसेस थे. बट इनको चिट्ठी दी गई थी by another, I think one of his colleague attorneys or something like that. Khan Gul versus Lakha Singh, crucial case law. जो आज का जो कानून है वो इसी केस लॉ पे बेस्ड है. एंड देन आफ्टर डिस्कसिंग दिस विल गो टू अयोध्या प्रसाद. तो खान गुल वर्सेस लखा सिंह के अंदर यही हुआ कि दैट देयर वाज एन इन्फेंट, ही मिसरिप्रेजेंटेड हिज एज, ही मॉर्गेज नहीं थी, यहाँ पे प्लॉट की सेल थी. एंड देन 17,500 रुपए, 17,500 इन 2 parts ही टुक. from somebody who wanted to be basically wanting to buy the plot. Now the main question, again you will have to elongate the facts from your case man. Main question is, can a minor who has entered into a contract by falsely representing his age, can he basically refuse कि बॉस हाँ मेरे को तो मैं तो minor ही हूँ, and at the same time get to retain the benefit as well? Well, here in this case, जज साहब का क्या नाम था? I think शादीलाल जी था. तो चीफ जस्टिस और जस्टिस शादीलाल जी, he said, look, सेक्शन 41 SRA तो आएगी ही आएगी इसके अंदर, बट यहाँ पे डॉक्ट्रिन ऑफ रेस्टिट्यूशन जो है, it does not extend to money cases in England. Key point, it does not extend to money cases in England. But herein he widened the scope of the doctrine and said, look, England and India are different, so circumstances are different. I, as a judge, cannot allow somebody, so this guy, to come to a code of equity and take advantage of his own wrong, because then justice का क्या हुआ? ये तो मुझे पता भी है कि आदमी गलत है, लेकिन मैं कुछ कर नहीं पा रहा. So he said, I'm going to expand the doctrine of restitution, and there is no difference in restoring a plot of land, restoring amount of money. अब पैसे तो पैसे ही हैं भाई, पैसा निकाल के दो वापस. पैसा ऐसा तो नहीं है कि तुम्हारे पास तुमने पैसे को ऐसा कन्वर्ट कर लिया होगा कि गाड़ी वाड़ी खरीद के अब पैसा तो मैं कहीं से ला ही नहीं सकता परमानेंटली. पैसा तो रहेगा ना, कैश तो everybody has. So just restore the 17.5. अब प्लॉट तो आप बेच नहीं सकते because you are a minor. So this doctrine was expanded. So section 31, section 33 of the new SRA. So 1963 के अंदर ये वाले sections यहाँ पे हैं. 39, 41 जो होते थे 1877 के एक्ट में, 31, 33 यहाँ पे हैं. So an infant could not be allowed to take advantage of his own wrong. This was the decision. So he widened this. ये जो restoration वाली बात थी कि provided that you can trace it, he widened it to money cases. Mention this point in your answer. Now, when we come to Ajudhya Prasad versus Chandan Lal, they said, no, what nonsense is this? हम नहीं मानते ये. We don't absolutely agree with at all this judgment. So they said, now again, short facts. 18 से 21 के बीच में दोनों ये माइनस थे, और इन्होंने falsely represent किया कि इनका guardian है, और again same, they took an amount for a mortgage. The judges said, we will strictly follow what? The doctrine of restitution, and we'll strictly follow this, that we can only restore the benefit whatever you gave unless and until it has been sold or converted. In that case, sorry, we cannot help you. So in this case, they said this doctrine cannot be extended to money cases in India. We won't allow that, since यहाँ पे we have to maintain a distinction between minor as a plaintiff, minor as a defendant. So these guys refused. So Ajudhya Prasad के अंदर sorry कर दी गई. खानगुल के अंदर ये कहा गया that we are going to expand the doctrine of restitution, and मोहरी बीबी के अंदर ये कहा गया कि doctrine of restitution हम नहीं अप्लाई होने देंगे because you did it wrong to begin with. तो wrong apply with expansion and completely overturned this decision. Present situation of the law is that law commission, they made the act, basically amended इन्होंने किया. So they agreed with Mr. Shadilal. 31, 33 sections अब हैं हमारे पास codified law, which says 2 points, these points that you have to mention. So void and voidable is जब cancel हो रहा है तो आपको restore benefits. Court may ask you to restore benefits in case of a void or voidable contract whenever it's cancelled. And if the defendant resists the suit on his incompetency, like this guy, कि boss मैं तो minor हूँ, या यहाँ पे मैं तो minor हूँ, यहाँ पे मैं तो minor हूँ, sorry, court can ask you to restore the benefits, and doctrine of those के अंदर हम पैसे वाले केस भी cover out कर रहे हैं अब से. So this is the final thing. So basically the law commission married, शादी कर ली इन्होंने मिस्टर शादीलाल से, and codify कर लिया अपना law. तो यही है हमारी बीवी में. Again, to sum it up, आप ये mention करेंगे doctrine of restitution, you're going to mention Leslie versus Shield, you're going to explain these 3 points, you're going to mention section 10, you're going to mention section 11, you're going to mention 41, you're going to mention 39, 41, 31, 33, you're going to mention now what is the current position of the law. You're going to mention Ajudhya Prasad was प्रसाद लेने गए, उनको हमने नमस्ते कर दी, क्योंकि ये केस लॉ जब था तब ये 63 वाली एक्ट नहीं थी. तो ये लॉ कमीशन ने भी देखा कि अरे बाप रे तो बहुत कंफ्यूजन हो रही है, तो हमें इसमें हल निकालना पड़ेगा. सो दे बेसिकली आस्क द मिनिस्ट्री टू अमेंड द लॉ. तो ये लॉ में अमेंडमेंट आ गई. तो अब यहाँ पर खानगुल में जो हुआ था कि ऐसा नहीं कर सकते आप, that an infant can be allowed to take advantage of his own wrong and come to a code of equity and basically dance there and say, look, you cannot touch me. All right, so that's about it. Thank you so much for everyone. Thank you so much to everyone who has given out a review on Google. It really helps us out. The link is in the description. All the very best to you for tomorrow. For people who are watching this later on other dates, I was shooting this on the 12th of December 2019. The DULLB semester ka exam is on the 13th of December. And I think this covers now pretty much everything. Playlist देख लेंगे, 60 नंबर आने की आशंका या पॉसिबिलिटी काफ़ी ज़्यादा हो जाएगी. आशंका बोलते हैं पॉसिबिलिटी को हिंदी में. Really don't know right now. Anyway, so hopefully it is clear, right? Wishing you all the very best. Do take very good care of yourself. Bye bye.